see how it's all tied in? 60 years here downtown Toronto. Up until 2014, the opening of the court ceremony was a three-part ceremony. For over 60 years, it started here at the Church of the Holy Trinity. Hundreds of the senior justice system participants, including the Federal Minister of Justice, the Provincial Minister of the Attorney General, the President of the Law Society of Upper Canada, the President of Legal Aid Ontario, all the senior judges of the province of Ontario, including Callo, who used to be the senior judge of the provincial court, and hundreds of them, lawyers and judges, police chiefs, all that type, used to meet here in the morning for a 2-hour, they called it the Red Mass, a non-denominational church service. Beginning in 2013, myself and a group of others, we were under the Canada Court Watch banner, began showing up and protesting this annual event, the opening of the court ceremony. And we would be out here with the bullhorns, challenging the judges and the justice system participants on what everybody knows is the absolute disgrace they call the administration of justice here in Ontario. There is not a more disgraceful force in our society today than the administration of justice. And by that I mean what goes on in the courtrooms and the courthouses of Ontario. And we showed up and started confronting the judges about their criminality, the ungodly collusion that goes on between the judges and the children's aid societies. People, if you think that the judges of Ontario don't spend thousands of hours on the telephone every year planning with children's aid society workers and lawyers on how to terminate family rights in their secret child and family services court, you don't understand the system. Because that's exactly what's going on. And we started confronting the judges. We were here 2011, 2012, 2013. We show up 2014, and lo and behold, they canceled the opening of the court ceremonies, Red Mass. They had been doing it for over 60 years. 3 years of bullhorn work, once a year, 2 hours, and the judges and the justice system participants folded like the cheap suits that they are. They could not stand being confronted, and we were hundreds of meters away from them inside the church. It's not like we were in the church with them. We were out here confronting them. And 3 years of that, a total of 6 hours of bullhorn work, and they canceled the morning Red Mass. Can you believe it? That is a very explicit admission on the part of the so-called justice system participants that they are the filth which the public knows them to be. Anything about the child protection systems? Ontario's is unlike anything in any other province in Canada. Ontario is the only province that uses private corporations. That's right, Children's Aid Society is a private corporation. Technically speaking, they're called a not-for-profit, incorporated without share capital, but very importantly, they have letters patent, and those are very, very powerful legal documents. They have articles of incorporation. They have local volunteer boards of directors. And that's one of the very distinct features of Ontario's child protection system. In every other province, child protection is done directly by a government ministry, which automatically obligates that ministry to freedom of information. So in every other province, people can do freedom of information on the local frontline child protection authority. Only in Ontario you can. Another very distinct difference in Ontario's system, Ontario is the only province in Canada where the frontline so-called child protectors have their own lobbyist and public relations firm. It's called the Ontario Association of Children's Aid Societies. We are the only province in Canada, think about that, where the child protectors have their own lobbyist and public relations firm. Is it any wonder that the state of child protection in Ontario, the state of the administration of justice in Ontario, is such a cesspool when you start to add up all these various factors? The Ontario Association of Children's Aid Societies gets approximately $9 million a year from none other than the Ministry of Children and Youth Services to operate. This system defies description. You cannot just say it's criminality. It's much, much more than just criminality. The only province where the frontline child protectors have their own public relations lobbyists, and the only province where the frontline child protectors are exempt from freedom of information. Those are the big three. There are more. The only province in Canada where the provincial ombudsman does not have the authority to investigate the frontline child protection authorities. Now, many people won't particularly agree with me on this issue, but I don't think that's a particularly severe one. I think that if the ombudsman gets jurisdiction, it's going to make about this much difference. Another thing, and Ontario is not alone in this one, but you'll hear the arguments about child protection workers not being obligated to join a professional college. Ontario has, I forget the number, perhaps somewhere around Ontario has perhaps somewhere around 40 professions where people have to join colleges if you want to participate in that profession. You'll know some of them: engineers, lawyers, doctors, teachers. There are, I think, around maybe 40 of them. But guess what? Child protection workers are not part of those professions which have to join a professional college. And that's not an accident. But again, my personal feeling is that if that change is made, it's not going to be a huge change for many complicated reasons. For example, professional colleges are not part of the Provincial Freedom of Information and Protection of Privacy Acts. So the public cannot do freedom of information on the professional colleges to test and to investigate whether or not those colleges are acting lawfully or against the public interest. That is a fundamental element anytime you're looking at an institution or a system. Ask yourself immediately, is that institution, is that system obligated to respond to freedom of information requests? If the institution or the system is exempt from freedom of information, then you know there is something fundamentally wrong in that process. The only reason to exempt entities from freedom of information is to cover up criminality. And that's why the courts of Ontario and the Children's Aid Societies are exempt from freedom of information. I don't know about you, but I want to know how many children in Ontario every year have their family rights terminated. Is it 500? Is it 5,000? I think it's probably a lot closer to that second number. Why can we get information about our military, our nuclear power plants, all kinds of very, very sensitive information just from straightforward internet searches, but you cannot find out how many children have their family rights terminated here in the province of Ontario each year? My God, is there any wonder the people of Ontario hold the administration of justice in this province in such contempt? From the summer of 2006 until the spring of 2015, non-stop, I did not have one day in my life where the province of Ontario's justice system participants were not litigating against me in court. And so, let me talk a little bit about what I learned. First of all, and in this, I'm speaking especially to my Irish-Canadian brothers and sisters, and to any Canadian who comes from a country where the English government and the English military did damage to that country. So India, Ireland, Scotland, there are numerous of them. When you are a defendant or a respondent, a defendant in the criminal court, a respondent in the Children's Aid Society's court, you have absolutely no obligation to stand up when the judges enter and leave the courtroom or when you speak to the court. I know. I just did a long, multi-year trial in Chatham, Ontario, Provincial Court Judge Paul Coalition, where I very simply refused to stand up in the courtroom during the hearings. Judge Coalition would say to me, Mr. Carter, would you please consider standing up when I enter and leave the courtroom? And when you speak to the court, would you please consider following the rules of the court? And I would respond to Judge Coalition, and I would say, why in the hell would anybody ever stand up for a judge in the courts of Ontario, considering the disgusting cesspool that is the administration of justice in this province? Why in the hell would I, as an Irish Canadian, ever stand up for somebody who swore an oath to the Buckingham Palace witch, multi-billionaire that she is? As an Irish Canadian, never should any of us ever stand up for somebody who has sworn an oath to the Queen of England. And I'm telling you right now, it is only going to be through disruptive actions such as these that we're going to force any change. If you, the people of Ontario, continue to stand up in court when the judges enter and when they leave, you're just playing right into their system. If you think the administration of justice is a cesspool, why are you standing up in court? Unfortunately, if you are the applicant, and I know this from personal experience, if you bring a piece of litigation to the courts of Ontario, as the applicant, you have no choice but to stand up in court, because if you don't, the judges, petulant little children that they are, will pick up their toys and go home, and they'll cancel your court appearance, and you won't have your issues litigated. But when you are the defendant, or when you are the respondent, you don't have to stand up.